Well, I want to thank the Dean, Professor Greenewalt, and the Dyson Foundation for that incredibly generous introduction and the honor of being here. I should say that I guess my skills as an instructor have deteriorated over the years, because sometimes I now get comments from my students who say he can take incredibly simple concepts and make them incomprehensibly complicated. But maybe that's just the law professor in me. The title of my talk, as you can see from the screen, is Play in the Joints of the Religion Clauses and Law More Broadly. And it's taken from a term that doesn't make its first appearance, but its most noteworthy appearance. In this case, the Supreme Court decided in 2004 called Locke against Davey. And so I want to talk a little bit about the Locke case and the origin of the term play in the joints before I then get to explain what I have in mind by trying to expand upon this concept. So the Locke case was out of Washington State, and it involved a student who got a scholarship and wanted to use it to study devotional theology in college. But the state had a very strict policy of separation of church and state. A lot of state constitutions have stricter policies of separation of church and state than the US Supreme Court has said our federal establishment clause of the First Amendment requires. And so the state said, well, you can use a scholarship to study anything, including some subjects about religion, but not actually to train to become a clergy member. That's where we draw the line, because that would be too much direct support from the state for religion. And he said, well, this is discrimination against me on the basis of my religion, because you're funding other kinds of study, but not religious study. Case goes up to the Supreme Court, and the question is, has the state of Washington violated the free exercise of the US Constitution made applicable to the states by the 14th Amendment by denying this student the opportunity to study devotional theology? And the Supreme Court first asked the question, well, does it violate the federal establishment clause for the state to spend the money this way? And they say, no, it doesn't. The federal establishment clause forbids some kinds of direct spending, but here this would not be a violation of the federal establishment clause. So it's possible it might violate the free exercise clause. But then Chief Justice Rehnquist said, but you know what? We're not going to say that either. We're going to allow that there is some room between what the establishment clause forbids in the way of accommodating religion and what the free exercise clause requires in the way of not penalizing religion. And he called this concept, citing an earlier case, play in the joints, meaning some room in between. And I can illustrate this graphically if this works. Okay, that's just another title page. Here's the idea, right? So if you look on the left-hand side, the blue region, those are accommodations that are required by the free exercise clause. So they couldn't completely exclude religion. Nice example of this might be, imagine that a state had a really, really strict policy of church-state separation that forbade, say, the fire department from putting out fires at houses of worship. Well, that would clearly be discrimination against religion. That would be forbidden by the free exercise clause. The free exercise clause would require the accommodation of that kind of exercise. At the other end are accommodations that the federal establishment clause forbids. So here you might imagine that the government had a policy of buying the King James Bible and requiring it as part of the curriculum in every school. Well, that would be clearly impermissible support for religion. But in between those two extremes, there is a region, which I've labeled in green here, where accommodation of religion is permitted but not required. And this is what Chief Justice Rehnquist called play in the joints. You can think of it as a kind of buffer zone. Right? So here's his language. There are some state actions permitted by the Establishment Clause, but not required by the Free Exercise Clause. And For years, this has been how I've understood the two religion clauses to work, right? That is, there's a recognition by the court, Chief Justice Rehnquist says this explicitly in the Locke case, that the principles of free exercise and establishment can conflict, but you want to separate them from each other so that actors who are subject to both, here that would be a state or local government or federal government, have some room to maneuver. So it's not the case that if you, you err a little bit too much in one direction, you end up violating one clause or the other. Unfortunately, recent cases from the Supreme Court suggest that the area in between free exercise and establishment has narrowed. There is now less and possibly no play in the joints between the two clauses. So I have in mind a series of cases, but the leading one is a 2022 case called Carson against Macon. In this case, Maine, which is, as you probably know, a very rural state, didn't have the funds to have sufficient public schools in every district. And so it had a program whereby parents could send their kids to private schools or public schools outside their district and have the state pay for it. But the state of Maine forbade it, the money to go to pervasively sectarian schools, right? So you can spend state funds even at religious schools, but not if they are pervasively sectarian. There's some debate about what exactly that meant. But in any event, this was challenged, and it looked a lot like Locke against Davey, right? That is, you have a state having a very strict anti-establishment principle, and you have a challenge to it on free exercise grounds. And the Supreme Court said that actually, this is forbidden by free exercise. You are discriminating against religion. Now, the court purported to distinguish the Locke case, but the way they distinguished it was really just to describe it and say, well, that was a case about funding for devotional theology, and that's not this case. Well, of course it's not this case, but the question is there a principled way to distinguish it? And the dissenters, on 8 separate occasions, cited play in the joints and say, you're narrowed play in the joints. So here I can describe it here. So this is, I apologize for the smaller print there. This is the way you might describe what's going on in Carson against Macon. There might still be an area in between free exercise and establishment, but notice that it's grown smaller, and notice also that the court has expanded the zone of free exercise, so the blue is much bigger there than in the previous slide, and shrunken the area of federal establishment clause. Now, a lot of people, including me, are critical of the court for shifting so much of the work of the religion clauses to free exercise, for shrinking establishment and expanding free exercise. But even if you don't think that, you might worry that the smaller area for play in the joints is problematic, especially if, as I think is possible just on a plain reading of Carson against Macon, they've shrunken it to nothing. So that now it might be the case that if something isn't forbidden by the establishment clause, some kind of accommodation of religion is not forbidden by establishment, it's required by free exercise. And the difficulty with that is not only that you've expanded free exercise at the cost of separation of church and state, but that you've narrowed the zone where actors subject to both decide what they're going to do to zero, so that if they err slightly in either direction, they're violating the Constitution. And it's my claim that this notion of play in the joints is actually very useful for understanding all sorts of other issues that face courts, legislators, and so forth. Before I do that, though, I just want to take a moment to distinguish the way in which I'm using play in the joints from the way in which it sometimes appears in the other cases. Now, as far as my research has been able to determine, the first time that the term play in the joints appears in a Supreme Court case is in this case that I'm sure you're very familiar with. It's a case called Bain Peanut. Bain Peanut Company of Texas, 1931. I had never heard of it either. It's an equal protection challenge brought by, I guess, the Bain Peanut people, that they claimed that a Texas law was denying corporations equal protection because it provided for venue in cases against them that wasn't available in cases against natural persons. And the Supreme Court, in an opinion by Justice Oliver Wendell Holmes Jr., says, no, 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 go away. That's not a valid equal protection claim. And he says, and anyway, there's got to be some play in the joints in the Equal Protection Clause. Now, it turns out that what Holmes meant by that is not what I mean by play in the joints. All he meant was that the court shouldn't interpret any constitutional provision too restrictively of government. Holmes, this was a time when equal protection was sort of out of fashion. People referred to the Equal Protection Clause often as sort of the last refuge of a losing argument. And so he's construing the Constitution narrowly, but not because he's worried that if he construes it, that there are two competing constitutional obligations and a narrow zone in between them. He's just worried that generally state and local actors should have greater freedom. He doesn't want to constrict the Texas lawmakers in how they define venue for certain kinds of actions. So my notion of play in the joints, or rather the Locke v. Davey notion of play in the joints, has some overlap with the Bain Peanut conception in that both involve wanting to give political actors some room to maneuver. But as I use the term, I'm referring to giving them room to maneuver from competing legal obligations. And when I say legal obligations, I don't necessarily mean competing constitutional obligations, as in Locke v. Davey. You can also have competing, two different statutory obligations. You can have a constitutional obligation competing with a statutory obligation. Now, you might think, well, how can that be? If you've got a constitutional obligation and a statutory obligation, if they're competing, the constitutional one prevails, right? Because it's supreme over a statute. And while that's true in theory, it's not always true in practice. So I have here in mind, if you think about the 303 Creative case from a few years ago, right? This is the case in which a web designer complained that she didn't want to have to design wedding websites for a same-sex couple because it violated her free speech principles. And to my surprise and chagrin, the Supreme Court agreed with her and held that it was a violation of her freedom of speech to require her under the antidiscrimination law to create this website. And the dissent by Justice Sotomayor, I think, is a nice example of how you can have competing constitutional and statutory obligations. What Justice Sotomayor said was, one reason not to construe the First Amendment free speech protection to provide protection for 303 Creative in this case is because if we do that, that's going to undermine statutory anti-discrimination law, right? So what she's saying is we shouldn't construe the Constitution in a certain way because we want to avoid invalidating a bunch of important statutes. Now, from a conventional standpoint, that seems backwards, right? We have a principle of constitutional avoidance whereby you construe statutes so that they don't conflict with the Constitution. But here she was saying we should construe the Constitution so that it doesn't conflict with the statute. And it turns out you see that kind of move everywhere. Even though it seems odd, it actually makes a whole lot of sense. Why? Because the Constitution is not self-defining. Often we're not sure what it means. And so you're thinking about, well, what would be the consequences of one construction rather than another? And it's not necessarily got any particular ideological valence. So for example, in Chief Justice Roberts' dissent in Obergefell against Hodges, right, the case recognizing a constitutional right to same-sex marriage, he offers as a reason why he's dissenting, why he doesn't want to agree with the majority, that this would invalidate lots of state laws, right? Well, again, the Constitution prevails in a conflict with state law, but he's saying, well, we don't have to construe the Constitution this way. We can construe it to avoid that problem. Okay, so you can have circumstances in which you can have competing legal obligations, whether constitutional, statutory, regulatory, state, federal, whatever it is. And the question then is, how should courts go about construing them when that happens? And my basic thesis is, well, we can see that it makes sense to try to construe them in a way that preserves play in the joints. That is to say, preserves that middle area where the persons or actors subject to the competing obligations have room to maneuver. Now, the core of this, of course, is what I'm calling intra-constitutional conflict. That is, conflict between competing constitutional obligations, like free exercise and establishment. And when I first started thinking about it, my first thought was, well, I'm not going to find many of those because generally the Constitution is applying to government actors, and then you can have other kinds of obligations, but for the most part, how is it going to be that we're going to have competing constitutional obligations? But it turns out once you start looking, you find a lot of them. So I think perhaps the leading example I found is a case from 1976 called Nebraska Press Association against Stewart. And this is a case that pits the First Amendment right of freedom of the press against the Sixth Amendment right to a fair trial. All right, so in this particular case, there was pretrial proceedings in a criminal case that had a lot of public interest. And the judge was concerned about pretrial publicity potentially tainting the jury pool. And so the judge wanted to give an order saying, well, the press can't come to the pretrial proceeding. We're going to have that in camera and without any kind of coverage. And a bunch of newspaper organizations sued and said, what are you doing? We have presumptively open courtrooms in this country. Let us come in and cover what's going on. And so you had freedom of press on the one side, and then the right to a fair trial of the defendant on the other side. The US Supreme Court eventually gets the case, and what they say basically is, well, you can only exclude the press if it's absolutely necessary to have a free trial, fair trial. Now, I should say, I don't disagree with that outcome exactly, but I worry that saying that you can only do one thing if it's necessary to avoid the other means that there's no play in the joints, right? That the court was saying in this case, it's either going to be a violation of the Sixth Amendment if you allow the press in, or a violation of the First Amendment if you keep them out, unless you strike the balance exactly correctly. And that strikes me as tough on trial judges who have to make these difficult balancing choices. I would have rather have seen the court saying, well, there's this gray area where it's up to the discretion of the trial judge. Now, fortunately, I think that's the way it actually works as a de facto matter, because if you look at the way these cases get litigated, and there aren't that many of them, but they typically do arise from time to time, what typically happens is a decision by a trial court judge to exclude the press or not to exclude the press is reviewed by higher courts for an abuse of discretion. So as a practical matter, there is a zone in which a judge could go either way without abusing their discretion, and therefore there is, as a practical matter, play in the joints. But the main thing I want to illustrate with the case is it's another example of intra-constitutional conflict. Here's another example that I think is less salient now than it used to be, but could have been quite important. Right? So in the wake of Brown against Board of Education, the federal district courts responsible for implementing the desegregation decree of Brown sometimes would order inter-district or intra-district busing, right? Assigning students from one school to another by race in order to purge the taint of the prior de jure racially segregated school system. And this was not only allowed, but in certain cases required to give an effective remedy. You may recall, right, that in 2007, the Supreme Court had before it a case in which school districts that were not seeking to remedy adjudicated instances of prior race discrimination, although they had engaged in segregation at some point in the relatively distant past, right? So in Seattle and Louisville had voluntarily adopted some use of race in assigning students to schools as an effort to integrate their schools. And the Supreme Court, an opinion by Chief Justice Roberts, somewhat infamous for his line, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race, right? But in general, his basic point was, well, you can't do this unless you're required to do it, right? That is to say, you can't use race as a factor in student assignments in public schools, except in circumstances where the Constitution requires you to. Now, notice what that means is there's no play in the joints, right? What he was saying was, in some circumstances, the Equal Protection Clause requires the use of race in student assignments, namely to remedy past de jure segregation. But in all other circumstances, that same Equal Protection Clause forbids it, right? So you have competing obligations both imposed by the Equal Protection Clause. Again, no play in the joints, and to my mind, that's unfortunate. And in fact, the dissenters made just this point, although they didn't use the phrase play in the joints because they seem to have that stuck in their heads as only something in religion cases. I want to give you one final example of intra-constitutional conflict, and then I'll move on to an important case of conflict between constitutional obligations and a statutory obligation. And that is in a very, very sad case from 1989, DeShaney against Winnebago County. This is a case in which this man was abusing his infant son terribly. And there were reports to Child Protective Services, and the Winnebago Social Services Department sent social workers out to investigate. And the social workers reported on it, that is to say, they made internal notes that yes, the child seems to have various bruises repeatedly, but never took any action. And eventually, this man beat his infant son, Joshua, so badly as to cause permanent disability. And so there was a lawsuit brought on behalf of Joshua against the county social services department, alleging essentially that their malfeasance or nonfeasance was so egregious as to be a violation of the substantive due process right to life and liberty of Joshua. Supreme Court, in an opinion by Chief Justice Rehnquist that I don't like very much, basically says, well, the state didn't beat him, it was his father did, so there's no state action here. There's no government action, therefore the Constitution doesn't have anything to say about this. Now, I don't like that result, but there is something that Chief Justice Rehnquist says in the case that actually does make sense to me, which is he says, well, look, the social workers in these cases are in a tricky position because if they act too slowly, they're going to be sued on behalf of the children who are then subject to abuse or neglect, right? But if they act too quickly, then they could potentially be violating the rights of the parents, right? That you're, and it's the same, he says, just like I observed a moment ago, how in the parents involved case, it's the Equal Protection Clause on both sides. Here it's the due process rights on both sides, right? And says so the Chief Justice says, well, you shouldn't put them in a kind of damned if you do, damned if you don't situation. Now, I agree with that observation. It just strikes me that you could nonetheless have a zone of play in the joints for the social workers that doesn't go so far as to include just mindlessly recording persistent abuse, right? So it's not that he's wrong that there should be an intermediate zone where social workers get to exercise their discretion. It's just that the zone I think that he's constructed here is too large, and certainly too large on the side of allowing the social workers not to intervene. For a useful comparison to this, I recently learned, Professor Waldman has a nice article that in the 2013 Connecticut Law Review that compares the same idea and uses the phrase play in the joint, so give her credit for that, in a very, very similar example where the question is how much private information that school authorities learn about students should they disclose to parents? Because on the one hand, you've got the privacy rights of the kids. On the other hand, you've got the parents' rights to direct the upbringing of their children. And there too, I completely agree, right? The answer is some, right? That is, you want whatever the right answer is for the rights of the students, not to be ratted out to their parents, and the rights of the parents to know what's going on with their kids. There's some zone in between where the school authorities should be able to exercise some discretion without running the risk that if they err in either direction, even slightly, they're going to be subject to liability. Okay, so that's the basic problem. Now I want to get to what I think of as one of the a recent missed opportunity for playing the joints. So, and this comes out of the recent campus protests over the war in Gaza. So, in response to campus protests, of course, there's been all sorts of publicity. One of the things that has happened, and this was under the Biden Department of Education, which I think is only going to be intensified now under the Trump Department of Education, is the Department of Education has taken the position that there are circumstances in which students are protesting the Israeli military's tactics, strategy, whatever they're doing in Gaza on campus in ways that are protected by freedom of speech, right? Maybe even if they're saying things that are offensive to other people. But at the same time, again, this is the Department of Education view, they can be engaged in freedom of speech, and yet what they are doing is creating a hostile environment for some of the Jewish students on campus, right? So the idea is that it's not a violation of anything, right? It's protected free speech to say, you know, from the river to the sea, Palestine will be free, or whatever the slogan is, right? Even if at the same time, some people perceive that, and the Department of Education is saying maybe correctly, as harassment in violation of Title VI. And so you wonder, well, how can this be? How could it be simultaneously protected speech and a violation of Title VI? And I should say, when I say protected speech, I'm envisioning a public university, right? So a state university or state-funded college, not just state-funded, but actually state actor. So it's bound by both the First Amendment and by Title VI. Although if you're interested, I can explain to you why I think this also applies to private universities like Pace and Cornell. But we'll put that aside. For our purposes now, let's assume that you've got, you know, a public university subject to both the First Amendment and to Title VI. And what the Department of Education has said is universities in those circumstances are not permitted to interfere with the student protesters' free speech, and that free speech creates a hostile environment for other students, and that the university is therefore obligated to take remedial measures. And you say, okay, so what are the remedial measures? Well, they offer two. They say one is you must engage in counter speech, right? Well, it's easy enough to engage in counter speech when people are saying things that are just simply offensive. On the other hand, when you have slogans that are politically contested, it's not clear that the university is going to want to engage in that counter speech. And in fact, universities around the country have recently been adopting the so-called Calvin principles from the University of Chicago, which say that the universities aren't going to take a position at all on controversial issues, and that forcing them to take a position, right, if the government says you have to engage in counter speech, that could be a violation of their right not to speak, right? And so you're in this odd position where the thing that the Department of Education is saying you must do as a remedy is itself potentially unconstitutional, at least as applied to the universities. Now, I know what you're thinking. If it's a state university, does the state really have free speech rights? That's where the part about how it applies to private universities comes in as well. We'll get to that. Second thing the Department of Education says you can do is, well, you should provide a welcoming environment to all of your students and offer counseling and so forth. Well, of course you should provide a welcoming environment to all of your students, but how is that a remedy for a hostile environment, right? In fact, not providing a welcoming environment would itself be a kind of hostile environment. And so it's not clear that that remedies the problem. And we can see that if you imagine the same issue arising in the Title VII context, right? Suppose you had one employee engaging in conduct that was consistently creating a hostile environment for some other employees. Well, would it be enough for the employer to say, I disapprove of those racist or misogynist things that those people are saying. This is my counter speech. And, you know, if you want counseling, I'll give it to you. But they're going to continue to engage in that racist or misogynist speech. Of course, that wouldn't be an adequate remedy. So it's not even clear that what the Department of Education is telling people that they ought to, telling universities they ought to do, remedies the supposed Title VI violation. And in fact, I think this is what it looks like. So here you have on the one hand, the First Amendment obligation to the protesters, right? The First Amendment says you have to allow them to protest, including saying slogans that are going to not just be offensive, but maybe create a hostile environment, right? And you've got, on the other hand, the Title VI obligation to those other students. And that area in the middle, that's not play in the joints. That's the area where the two cross so that you have an obligation to do both, so that you're stuck and anything you do is going to violate one obligation or the other. It's not just that you have to guess exactly right where the line is, as when the court arguably eliminated play in the joints in Carson against Macon. It's that literally you are faced with conflicting legal obligations, and so you're going to be liable to somebody. That is plainly an untenable situation, right? It's sort of the opposite of play in the joints. I don't know what that would mean, joints in the play or something like that. But in any event, that to me shows what's got to be wrong with what the Department of Education has done there. I'm not going to now offer exactly what I think they ought to do in response, except it does strike me that whatever the Department of Education does should allow universities some discretion, some zone in between where they're not, certainly where they don't have conflicting obligations, but ideally where there's a substantial zone of discretion to allow speech, to take countermeasures, and so forth. Okay. Finally, you might ask, well, what are the virtues of play in the joints? Well, I think they're just, I'm just going to very briefly list them because I want to leave a little bit of time for some questions. So I'll say first and most importantly, right, play in the joints serves the principle of judicial humility, right? Insofar as it's courts that are doing this, right, they should not assume that they can draw the line exactly where the values should be compromised, but rather actors closer to the ground should have some ability to do this, right? It's related to the now overruled Chevron doctrine. Now that's about experts in agencies, but the thought might be here that, you know, universities are better able to balance the rights of different students than is the Department of Education, by, you know, which, you know, might cease to exist in the next 15 minutes anyway. Whoever the actors are. So judicial humility works there. And that sort of overlaps with that Bain peanut idea I talked about before. Second value here is fair notice, right? Because a lot of the legal obligations are often vague, it's unclear where one ends and the next begins. Right? This is often true of legal obligations, but usually if you're subject to only one legal obligation and it's vague, you can protect yourself by sort of going a little bit farther than you need to go, right? You sort of, you create sort of a prophylactic measure, and you say, well, we're going to do what we know is going to protect us. We're going to engage in conduct that falls within a kind of safe harbor. So if you're not sure whether the line is here or here, you do something over here that's well short of the line. Problem is, if you've got a conflicting obligation on the other side, right, the more you move away from this obligation on this side, you move and potentially you violate the legal obligation on this side. So play in the joints is, I think, essential to fair notice when you've got inherently vague legal obligations. And the claim here is not original to me, but that all legal obligations have some vagueness, at least around the edges. Third virtue is in cases like Locke v. Davey itself, in cases of state universities, federalism, right? Often these actors, if they're state actors, are going to be subject to federal regulation, And the notion here is that federalism or decentralization is generally a virtue. Finally, play in the joints serves what we might call the value of freedom, right? Whether it's an individual, state, private firm, right? It could be individuals, right? There are circumstances in which a natural person could be subject to potentially conflicting legal obligations. And it's a general principle that they ought to have greater freedom to decide for themselves what to do rather than thinking at every moment, well, how do I comply with all of my legal obligations, right? Another way to put that is the law can basically take three stances with respect to any action. It can require it, it can permit it, or it can forbid it, right? And the claim here is simply that, well, unless there are really good reasons to require it or forbid it, the position of the law ought to be to permit it, right? And so that's the sort of virtue of freedom that you get from play in the joints. Finally, I should say there is a downside to play in the joints, and the downside is that it does mean that whatever values you have on one side or the other, one or the other of them is going to be sacrificed a bit relative to what you, the judge or whoever it is, thinks is the ideal balance, right? So allowing play in the joints, again, it's like the notion of Chevron deference, right? It means allowing somebody else to decide how to strike the balance between the values that conflict in the law. And that is, I suppose, a downside, but it's only a downside if you believe that the person, whether it's a judge or some other actor, who's making the decision for everybody else, knows better where that line should be drawn. And so in that sense, it's not really a downside. I said finally a moment ago, now I'll say really finally. I've talked about play in the joints as a strategy for courts to use in construing potentially conflicting legal obligations, but there's an obvious lesson as well for lawmakers, including constitution writers. And the lesson there is, whenever possible, try not to give actors subject to your regulatory authority conflicting legal obligations. Now, I say whenever possible because it's not always possible. What I mean by that is, if you're a value pluralist like I am, like that is you think there are a lot of things that are valuable, equality and liberty, right? You will recognize that sometimes those values come into conflict. In addition to that, it's not always possible to specify in exact detail all of people's legal obligations. And so the law necessarily includes some standards as well as rules. And even rules, as I noted earlier, will have uncertainty around the edges. And so there will be zones of conflict that you don't anticipate, right? And so therefore, even if lawmakers, constitution writers do everything they can to leave that buffer zone, that area for play in the joints, there is going to be some cases in which judges on the ground are going to have to construe potentially conflicting legal obligations. And my hope is that, going forward, they do so with giving more and more play in the joints. Okay, thank you so much for your attention. I'm now delighted to answer your questions.
Thank you so much for that wonderful lecture. I would like to present you with this gift commemorating your lecture. And absolutely, we would love to hear some questions. Would you just like to call on?
Why don't you call on people?
Okay, questions? Yes.
Sorry, is this better? Do you think by the Supreme Court eliminating the play in the joint or the play in the joints doctrine, it gives them more freedom to eliminate some really important precedents like the Obergefell precedent and the abortion rights, same-sex marriages, and everything else?
So I don't think there's a necessary connection between that, right? As I indicated with the second slide, we go back to that one, right? It's possible to shift the zone without eliminating it, right? So you could have, if you just had a shift, that would still, you could move the law in any ideological direction you wanted while still retaining play in the joints. But having said that, I will say that I think there is a kind of connection at the level of vibes, right? Which is that a court that is very confident in its own judgment so confident that it's going to discard precedent, routinely, right, is also likely to be confident of its own judgment relative to other actors, and so not leave them room to maneuver, right? So the same kind of judicial arrogance that leads to what we might think of as too ready overruling of well-established precedents, I think can also lead temperamentally to not leaving a lot of room for play in the joints.
Hi, Professor Paul Rink. It's nice to meet you, and I'm very thoroughly convinced by your argument from a theoretical standpoint. But I'm also noting that we're in a period where there tends to be judges that are seemingly more ideological and probably less willing to give up some of their ability in terms of making determinations that would allow for this play in the joints that you're describing. And I guess I'm wondering, based on your historical research, forgive me for asking to be a bit predictive, but do you think that this is something that's more of an aberration of our time? Or do you think that this is something that trends in this direction within the judiciary over long periods of time? And do you think, based on your historical research, there's any chance that things might shift toward this actually happening in practice based on judges making less prescriptive decisions based on their own personal ideologies?
Yeah, so on the sort of question about the sort of ideological composition of the courts now, I think that I share your sense that the courts are more ideological, but perhaps in the following sense. That is, political polarization has increased, and so that started in the House of Representatives, right, where you had safe districts because of political gerrymandering and maps and so forth, spread to the Senate, and it's now spread to the courts, right? So that, at a time when the most conservative Democrats in the Senate were more conservative than the most liberal Republicans, right, you had generally more centrist judicial appointees. As that shifted, now Democrats tend to appoint more liberal judges and Republicans appoint more conservative judges, right? And so, right, this is why, the lawsuits against the Biden administration were all filed in the Fifth Circuit. The ones being filed against the Trump administration are being filed in the First and the Ninth Circuits, right? So there's no doubt that, right, judges have stronger ideological views. I guess my previous answer, right, which said like judges who are confident in their own views and they're going to be more confident with a greater ideological valence. If they're more confident in their own views, they're less likely to give anybody deference. And so I think that you're right that there is a kind of utopian quality to what I'm proposing. But having said that, I think there are a lot of circumstances in which the risk of competing legal obligations doesn't have any obvious ideological valence. And so I think there's value in simply pointing out that this is a useful tool in those circumstances. I mean, I think it's useful in all circumstances, but at least there will be cases in which, the stakes aren't ideological, but you're saying, well, there's a tax obligation and there's a bankruptcy obligation. Let's not construe them to cross, and let's leave some ground. And so at least there, I hope that there's some room.
Thank you.
I have a sort of follow-up to your answer to that question, which is I wonder if one of the ideological commitments here is rule of law. And I don't think I agree with this myself, but I'm sort of channeling maybe Justice Scalia that when we remove the play in the joints, we make outcomes more predictable. It may create more conflict or more might reduce satisfaction in the law in some way, but it creates predictability. I mean, it's sort of like a textualism writ large. Like we just know what it says, and that's what we're sticking with. We get rid of the gray area in the middle, and we know what the outcome will be. Whether we like it or not is a different question. Is that a plausible argument for reducing play in the joints as much as possible?
Yeah, so I'm glad you said you don't agree with this argument, because I also don't agree with it. And I don't even think it makes sense, right? That is to say, what the court would be saying in a case like Locke, what the court is saying in a case like Locke against Davey is, here's the line. We, the court, are drawing the line at what the Establishment Clause forbids. It's exactly here, to the extent that they can be precise about that. here's the line for free exercise. We say it's exactly here. So there's no ambiguity about what the law is requiring or forbidding, and the court is being as precise as possible, but they're just drawing it here and here rather than here and here, so that there's a zone in between. By the way, that was going to be my answer to the question that somebody was going to ask me about how can you keep citing Chevron in light of Loper-Bright, and the answer is, well, Chevron purports to be a construction of the Administrative Procedure Act, which says that courts get to draw the line. A, most of these cases don't involve the Administrative Procedure Act, and B, I'm still saying the court gets to draw the line. It's just saying that they get to draw the line in a way that confers discretion, and conferring discretion is different from what the court says you can't do in a case like what they say you can't do in Loper-Bright, which is you can't say that when Congress writes ambiguous statutes that confers discretion. That just creates ambiguity that courts have to resolve. I'm still saying courts can resolve the ambiguity, just do so in a way that says what the law means for a certain zone is. This action is neither forbidden or required, it is permitted.
Hi, I was just wondering if you could go more into depth about the private sector of education, because from my perspective, it seems like there would innately be a gray area, kind of balancing the law and the requirements that they put forth for their own school.
Yeah, great. So so private universities are not bound by the First Amendment. They could, if they so chose, forbid all sorts of protests that a public university can't forbid. But nearly every private university in America, this is true of Pace, it's true of Cornell, right, values freedom of speech as part of our educational mission, so we don't want to do that. And so, you know, that's not really an option, right? It is an option to draw the line somewhat differently from where the public universities do, but you don't have the option of just sort of eliminating freedom of speech, nor would you want to take advantage of that. Moreover, and this is the point I was alluding to when I was talking earlier, right? I actually think that insofar as Title VI is construed to require universities to crack down on their students, if the students are engaged in freedom of speech, then Title VI is unconstitutional as applied. And this actually arose in the case that Harvard has now settled, but before Harvard settled it, there was there's a lawsuit by a Jewish student against Harvard claiming that Harvard's actions with respect to the anti-Gaza war protests and various other actions were anti-Semitic in violation of Title VI. One of the defenses that Harvard offered was to say, well, what about the First Amendment rights of our students? And so the judge, I think quite erroneously in the summary judgment opinion, says, well, I'm not going to decide that question, but I'm highly dubious that you can raise that issue. After all, you're a private university. You're not bound by the First Amendment. You don't have to respect any First Amendment rights. And yeah, Harvard is a private university. If there were no Title VI and no judge telling them what they have to do, then Harvard could on its own crack down on the student protest. But if you construe a federal statute to order a private actor to violate other students' rights, then you're converting the private actor into a kind of arm of the state. Now, I know what you're thinking. What about the net choice cases? What about not net choice, the other big case from last time, the case by the state, Missouri against Murphy, right? So there, the question was whether the Biden administration's pressuring of social media companies to deplatform, essentially anti-vax and election denial speech, turned the platforms into state actors as against the people who were deplatformed. Supreme Court ultimately dismisses on standing grounds, but nobody doubts that if the Biden administration had literally ordered YouTube, or what was then Twitter, to take down other actors' speech, then that would have been state action as against those third parties. It's just that the claim was that this was mere jawboning, right? So actually, the government actually telling a private university, you must restrict other third-party speech, that is state action. I think that is a First Amendment violation, if the speech is protected.
We have time for. Out.
We do have a reception afterwards, so if you're available, and I believe you are, you will be attending the reception.
Yes, I plan to be here.